Before anyone investigates a crime, somebody has to decide one happened. Not a jury, not a judge, one person. Usually, the first officer on scene, sometimes a sergeant, sometimes a sheriff standing in front of a microphone, makes a call. Is this a crime? Is this an accident? Is this nothing at all? That call happens in the first hour, sometimes the first 10 minutes. And everything that follows, every resource, every search team, every piece of evidence that gets collected, or doesn't, flows from that one decision. Welcome to Help Solve the Case. I'm Christine Burke. I'm a 25-plus year investigator, law enforcement expert, and forensic genetic genealogist. And for the next several episodes, I'm going to talk to you about how the crime or no crime decision gets made, who makes it, and what happens when it's wrong. Thanks for being here. I'm going to walk you through real cases, some closed, some still unfolding, where that single decision changed the entire trajectory of an investigation. Not because anyone necessarily broke the law, because someone, in a moment of pressure, judgment, or plain exhaustion, decided what kind of case this was going to be before all the facts were in. This is episode 1, the decision point. Here's a phrase you've probably heard if you've ever called the police about something that felt wrong to you. That's a civil matter. I want you to understand what that sentence actually does. It's not a neutral observation. It's a classification decision. And once it's made, a report often doesn't get written, a case number doesn't get generated, and no investigative resources get allocated. The event you experienced didn't just go uninvestigated. In the system, it may functionally not exist. There are 2 honest reasons this happens, and 1 dishonest one. And I've watched all 3 play out over my career. The first is workload. An officer at the end of shift, looking at a report that means 2 more hours of paperwork, sometimes makes the call that lets them go home. It's not a conspiracy. That's fatigue and understaffing. And it happens more than departments want to admit. The second is judgment, a genuine, reasonable judgment that the facts don't support a criminal case. Not everything that feels wrong to a victim meets the legal elements of a crime. That's real too. The third one is the one people don't want to talk about, the Uniform Crime Report. Every agency in this country reports crime data to the FBI through the UCR program, and increasingly through the newer NIBRS system. Those numbers get published. They get compared year over year. They show up in city council meetings, in mayoral re-election campaigns, in a police chief's performance review. A lower reported crime number looks like a safer city. It looks like a department that's working. I'm not telling you every agency manipulates its numbers. I am telling you the incentive exists. It is well documented, and it means the decision to classify something as a crime is never made in a vacuum. It's made by a person who may be tired, may be exercising legitimate judgment, or may be thinking, even subconsciously, about what that report does to a number somebody upstream is watching. This isn't hypothetical, and it isn't new. A survey of retired NYPD commanders published back in 2010 found a pattern of pressure from department leadership to downgrade serious crimes into lesser categories to keep the department's comp stat numbers moving in the right direction. More recently, and much closer to today, as of this recording, the Department of Justice has opened an investigation into whether Washington, D.C.'s police department manipulated its own crime statistics to make the city's declining crime narrative look better than the underlying numbers supported. I'm not telling you the outcome of that investigation. It isn't finished. I'm telling you the DOJ found the allegation credible enough to open a federal inquiry. Different decades, different cities, Same incentive. One more piece of mechanics, because it matters for how you read crime news generally. For decades, the UCR system asked agencies to report only the single most serious offense in an incident. So if a burglary turned into an assault, only the assault got counted, and the burglary disappeared from the numbers entirely. The newer system, NIBRS, is supposed to fix that by capturing every offense in an incident, not just the worst one. Most agencies have made the switch. Some still haven't, years after the deadline. Which system a department uses changes what the numbers actually mean, and almost no one watching the evening news knows to ask which one they're looking at. That's the front door. Now let's talk about the back door. How police close the cases they do open. When a case is closed, the FBI's system recognizes exactly 3 outcomes. Cleared by arrest, someone was taken into custody and charged. Exceptionally cleared, the department knows who did it and has enough to arrest, but can't, usually because the offender is dead, already in custody in another case, or a prosecutor declines to move forward. And unfounded, a determination that, after investigation, no crime actually occurred. Kind of like those civil matter things. Here's the part that should bother you. There is no national standard for when a department uses exceptionally cleared. Some agencies use it constantly. Some barely use it at all. That single inconsistency means the number you see reported as a clearance rate in one city cannot be honestly compared to another. Cleared sounds like solved. It frequently isn't. Unfounded has its own history of abuse, and it's worth knowing before I show you the cases. In the late 2000s, an audit of the Baltimore Police Department found its rate of unfounding rape reports running roughly 5 times the national average, and nearly 40% of calls reporting a sexual assault were never even forwarded to a detective for an investigation. When investigators went back and reviewed those unfounded complaints, about half of them turned out to be misclassified, meaning the department had already decided before any real investigation that no crime happened. And let's just not talk about untested sexual assault kits and unsolved sexual assaults, okay? Disgusting. New Orleans had a version of the same problem. A city inspector general audit found 46% of tested sex offense reports had been mislabeled as something other than what they were actually. I'm giving you those numbers because unfounded is not a rare, careful, evidence-based designation every time it's used. Sometimes it is exactly that, and sometimes it's the fastest way to make a case disappear from the books before anyone investigates it at all. And here's the part that matters. If you've ever tried to get a police report on something that happened to you, if an incident is never classified as a crime, there's often no report to request it in the first place. No case number means no paper trail. That's not an accident of bureaucracy. For the person standing at the counter being told that's a civil matter, it's the entire ballgame. So how do you know, as a private citizen, if this has happened to you? A few signs I'll tell you to watch for. If you report something and you're told it's a civil matter without anybody taking a report or taking a statement or writing anything down, that's a decision being made without documentation. And documentation is the only thing that lets anyone check the decision later. If you ask for a case report or a report number and you're told there isn't one yet or there won't be one, ask, in those exact words, whether your report is being classified as unfounded, and ask for that determination in writing. Departments don't love putting unfounded on paper next to a citizen's name because paper creates a record someone can audit. And if you're told a detective will follow up with no time frame, write down the date, the officer's name, and their badge number, not because you're building a lawsuit, because 6 months from now, When you're trying to figure out whether anything happened at all, that scrap of paper is the only record that will exist independent of the department's own file. I'm walking you through this process because, first, you can't understand what happened in the cases I'm about to show you without it. 2 families this year ran directly into this decision point. One case is closed to a working theory the family rejects. One case took days to even be treated as a crime scene. Same process, same decision point, very different public visibility. On February 1st of this year, Nancy Guthrie, the 84-year-old mother of Today's Show anchor Savannah Guthrie, was reported missing from her home in Tucson, Arizona. She'd been dropped off at home by her son-in-law the night before, around 9:48 p.m., after having dinner with her daughter. She never showed up the next morning to watch a church service at a friend's house. Now watch the classification decision happen in real time. An 84-year-old woman doesn't show up somewhere she was expected. In law enforcement, there is a well-worn category for that: the elderly walkaway. Dementia, disorientation, wandering. It's a real phenomenon, and it happens enough that it's genuinely the first working theory many agencies reach for. I want to be fair to that instinct. It is not automatically wrong to consider it. But here is where the decision point matters. While that theory is being worked, what happens to the house? On February 2nd, Pima County Sheriff Chris Nanos stood in front of cameras and said something that shifted the entire case. Quote, "We believe now, after we process the crime scene, that we do, in fact, have a crime scene," end quote. That's the moment the classification flips from a wellness concern to a criminal investigation. But classification isn't just a label. It's supposed to trigger a resource allocation. And here's what the sheriff himself later admitted about how that allocation actually went. By his own account, the home was released back to the family and the crime scene tape came down, then had to go back up days later for further processing. Nanos told reporters, quote, "I probably could have held off on that," end quote. The FBI's director, Kash Patel, said his agency wasn't allowed into the investigation for 4 days, and that the delay likely cost investigators Nest camera footage that may have been permanently deleted by the time they got access. By then, people had already been allowed to walk up to the front door, the same porch where Guthrie's blood was later confirmed. I want to be precise about what I'm showing you here, because this is not me second-guessing a sheriff from a studio chair. This is the sheriff on camera, describing his own department's sequence of decisions. Release the scene, delay outside help, resecure the scene days later. Every one of those is a resource decision, and every one of those flows backward to that first classification call. How urgently do we treat this in hour 1? Sheriff Nanos has said that the Guthrie family, every sibling, every spouse, has been cleared as suspects and has described them as cooperative and, in his words, victims in this case. A man seen on nearby surveillance carrying backpacks was also ruled out. As of this recording, the case remains open. No one has been arrested, no confirmed proof of life. There's a detail in this case that deserves more attention than it's gotten. A neighbor has said she begged deputies to investigate the empty house at the very start, before the crime scene determination, before the tape went up the first time. That's the walkaway theory colliding with someone on the ground who didn't buy it. I've been on both sides of that conversation. The resident who's certain something's wrong and the responding officer weighing that certainty against 100 other calls on the board that night. The officer isn't always wrong to be skeptical, but when the person raising the alarm turns out to be right, the department doesn't get credit for moving fast. It only gets scrutiny for moving slow. Put yourself for a second in Annie Guthrie's position. The daughter who had dinner with her mother that night, whose husband dropped her off at 9:48, and who then had to watch a sheriff stand at a podium and describe her mother's home in real time as something the department wasn't sure was a crime scene yet. The family isn't just waiting for answers. They're watching the classification decision happen in public, understanding, the way I do, that every hour spent debating the category is an hour not spent running down whoever if anyone was actually there that night. Now, think about this from a prosecutor's chair, because eventually, if this case produces a suspect, someone in a district attorney's office has to build a case with whatever evidence survived those first few days. Chain of custody, scene integrity, the window in which physical evidence was exposed to anyone who walked up that porch. All of that becomes cross-examination material for a defense attorney, regardless of who's eventually charged. A prosecutor doesn't get to prosecute the case they wish they had. They prosecute the case the first 4 days left them. If I'm the on-call detective getting that first call about Nancy Guthrie, my instinct is boring and unglamorous. Treat the residents like a scene until someone can prove to me it isn't one. That costs a few hours of tape and a patrol unit's time if I'm wrong. It costs irreplaceable evidence if I'm right, and I didn't. Here's my professional read from 25 plus years of doing this work. The walkaway theory isn't the problem. Working a theory is what investigators are supposed to do. The problem is what a department does with the physical scene while that theory is being tested. Evidence doesn't wait for you to make up your mind. It degrades, it gets contaminated, it gets deleted off a server. The moment you treat a scene as low priority, you don't get that moment back, even if you correct course 3 days later. Money matters here too, and I'll go deeper on this later in the series, but here's a preview. Search and rescue aircraft run anywhere from roughly $1,200 to $3,000 an hour, depending on the equipment. And a multi-day ground and air search can run into 6 figures before anyone finds anything. Guthrie's search plane sat grounded for hours early on over an internal personnel dispute that had nothing to do with her case. That's just not lost time. That's a resource decision, whether that specific asset flies now or later, made for reasons that had nothing to do with the classification question I've been walking you through. When I get the money episode later this season, when I get to the money episode later, I'm going to show you exactly what departments spend chasing a maybe versus what they spend once something is confirmed as a homicide, and why that gap is bigger than most people assume. That's Guthrie. Now I want to show you a case that's happening right now in real time, where we don't yet know how the story ends. On July 4th of this year, 18-year-old Nolan Wells, a football player at Southwest Mississippi Community College, took a boat trip with friends to Horn Island, a remote barrier island off the Mississippi coast. According to authorities, Wells stayed behind on the island after his friends left. His body was later found. The sheriff's office working theory is accidental drowning. Investigators have stated they see no evidence of foul play. The family disputes that. They've retained civil rights attorney Ben Crump, and they ordered an independent autopsy. Crump has said the family was told investigators see no evidence of foul play. Quote, even though you have students who recorded an altercation while they were on the boat, end quote. His description on camera was that Wells and another person were, quote, yelling at one another, end quote. I want to be exact about what is and is not established here. A disagreement on a boat, caught on video, is not evidence of a specific cause of death. It is evidence that something happened that the family believes was not fully run down before the sheriff's office settled on a working theory. There's another wrinkle in this case worth understanding, because it's going to come up again and again in this series. Citizen-recorded video sitting on someone else's phone is not the same legally or practically as video collected and logged as evidence. If investigators have seen the altercation footage Crump described, the question isn't just what's on it. It's whether it was properly obtained, preserved, and its chain of custody documented from the moment it existed. If it hasn't been formally collected yet, every day that passes is a day that can be lost, deleted, or edited, intentionally or not. A civilian's phone is not an evidence locker. How urgently that footage gets secured is, again, downstream of the same classification call I opened this episode with. How seriously do you treat this right now before you know what it turns into? The independent autopsy that the family commissioned has come back inconclusive, cause of death undetermined. That's an important, honest detail, and I'm not going to oversell it. An inconclusive independent autopsy doesn't prove foul play any more than the sheriff's working theory proves it didn't happen. What it does leave is a classification question genuinely open, in public, in a case that's still active. Let me put my training hat on for a second, because this is where undetermined gets misunderstood. A body recovered from water after timing the elements presents real limits on what a medical examiner can establish. Water accelerates decomposition. It can wash away or mask soft tissue injuries that would tell a pathologist whether someone struggled, was restrained, or was incapacitated before they went in. Undetermined isn't a pathologist being cagey. Sometimes it's the honest ceiling of what a body can tell you, however many days later. That's exactly why my training holds every death as a homicide until the medical examiner says otherwise. Not because every death is a homicide, but because you don't get a second chance at the evidence a decomposing body stops giving you. Now put yourself in the sheriff's office for a second, because I want to be fair to that side too. No evidence of foul play is often the first and most defensible thing an agency can say publicly, precisely because it commits them to nothing. It's not an accusation, it's not a clearance, it's a placeholder while the file stays open. The risk isn't in saying it. The risk is in treating it as the final word instead of a placeholder and moving resources off the case as if the placeholder were a conclusion. And there's a prosecutor in this story too. The family met with the Jackson County District Attorney's Office, and by their attorney's account, it was a respectful conversation, which tells you the DA hasn't closed the door on this file either. A DA doesn't need to publicly declare a theory to keep a case alive. They need the sheriff's office to keep building the file as if charges were still possible, not as if the manner of death were already decided. The family's ask, in their own words, has been simple: transparency. In their own words, the accidental drowning conclusion made, quote, both me and his father uncomfortable, end quote. That is a family asking, in real time, for the same thing every family in a Guthrie-type situation eventually asks for after the fact. Don't settle the classification before you've exhausted the alternative. Here's where I paired these two cases for this episode. Guthrie shows you what the decision point looks in hindsight. Guthrie shows you what the decision point looks like in hindsight, after a sheriff has already admitted what he'd do differently. Wells shows you what it looks like while it's still being decided, while the working theory and the family's account are sitting side by side unresolved, and the classification hasn't been locked in yet. I want you watching this case the way I would as an investigator, not rooting for one outcome, but paying attention to whether the process, full forensic workup, full accounting of that recorded altercation, full transparency with the family, actually happens before the case file gets closed as an accident. Because once it's closed, reopening it is a much higher bar than getting it right the first time. And there's a perspective in this case that's easy to lose in a debate about clearance categories and working theories. An 18-year-old college kid, days after visiting a remote island with friends, doesn't come home. His teammates are grieving. His hometown is grieving. And they're doing it while a technical procedural argument about classification plays out over their heads, in press conferences, in filings, in a language most people never have to learn. That's true of Guthrie's family too. The process I'm showing you in this episode isn't abstract for the people living inside of it. Two cases, two different public profiles, same process underneath. Somebody decided early what kind of case this was. That decision determined the resources. In the Guthrie's case, we now know, because the sheriff said so himself, that the early decision cost the investigation time and potentially evidence. In Wells' case, we don't know yet. The classification is still being contested in public by a family that isn't satisfied it's been fully tested. And this isn't just a two-case problem. I showed you Washington, D.C. under federal investigation right now for the numbers side of this. I showed you Baltimore and New Orleans, both audited for the unfounded side of this. Guthrie and Wells aren't outliers. They're just the two cases this year where a family had the platform and the resources to make the decision point visible to the rest of us. Most families don't get that. Most of this happens quietly in a filing cabinet with no one outside the department ever finding out a decision was made at all. This is the pattern I'm going to keep showing you throughout this series, and I'm going to show it to you through these two cases in full, not just the highlight reel I gave you tonight. In the next episode, I'm taking you inside Nancy Guthrie's case hour by hour, the first 96 hours, the exact moment the classification flipped, and what it cost once it did. After that, I'm taking you inside the Nolan Wells case while it's still alive, and the question that's actually at the center of it. When a family says this doesn't add up, and a sheriff says there's nothing to see, who is supposed to be right? And who decides? After that, I'm putting a real number on what all of this costs the department in dollars. And after that, I'm taking you inside the medical examiner office itself, my own training that every death is a homicide until someone with the right credentials says otherwise, and what happens when that person is understaffed, underfunded, or doesn't exist yet because there's no body to examine. And after that, we turn towards every person standing in the blast radius of that decision. The medical examiner, the prosecutor who inherits whatever evidence survives the first 72 hours, and the families who have to live inside the gap between what a department says publicly and what it's actually doing behind the tape. That's where we're headed. Two cases told in full, and everyone standing on every side of the decision that shaped them. So, who decides when a crime has occurred? Right now, in two different counties, two different men in two different uniforms are answering that question. One in hindsight, one in real time. I'll be back next episode to take you inside the exact process behind It's a Civil Matter and why keeping crime numbers down is worth more to some departments than getting them right. Subscribe so you don't miss it. I'll see you there. Who decides when a crime has occurred? Right now, in two different counties, two different men in two different uniforms are answering that question, one in hindsight, one in real time. I'll be back next episode to take you inside the first 96 hours of Nancy Guthrie's case, decision by decision. Subscribe so you don't miss it. I'll see you there.